These prosecutors have weaponized our justice system against its political opponents, and it is Congress's duty to respond, which is why I have introduced this bill and a similar bill from last Congress, which would give both current and former presidents and vice presidents the ability, not a mandate, but the ability to remove their civil or criminal cases against them from a state court to a federal district court. The new bill also expands the eligibility to remove cases also to current and former U.S. officers who are acting within the scope of their official duties or apparent legal authority related to their office. The bill also codifies the immunity recognized by the U.S. Supreme Court for official acts carried out by federal officials. The federal interests implicated by civil actions or criminal prosecutions brought against current or former presidents and vice presidents are pretty overwhelming. A federal court is the appropriate forum to adjudicate cases with such a strong federal nexus. Federal judges, as an example, enjoy life tenure that is largely free from outside interference in their decisions. By contrast, state court judges are readily subjected to political influences, as many of them are often elected or directly appointed or serve shorter terms. In federal court, the jury pool is often drawn from a larger and more diverse district. The rules of jury selection are much more robust than in state court. This helps to ensure that the political biases of one locality do not improperly influence the jury and its decisions. And so we must ensure that state courts are not weaponized against current or former presidents, vice presidents, or U.S. officers. This is common sense. We can and should act to provide this option of a fair playing field for legal proceedings for all presidents, vice presidents, U.S. officers, former and current. I urge support, and Mr. Chairman, I yield back.